Somebody don't want to have sex with you and they tell you no, you don't have sex with them. Because then guess what? It's not consensual, it's rape. Versus Eric Deleriva. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
Defense?
Austin Hagee for defense.
And are you Deleriva?
Yes, sir.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Mr. Deleriva, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney?
Yes.
Did you understand it?
Yes.
And did you sign it?
Yes.
Next, I'm showing you the true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, we have one oral amendment that we've agreed to with the state on count 2. We're taking off.
We're going to get to that. So do you waive the reading of the indictment?
Yes, I do, Your Honor.
State, are you proceeding on the indictment as presented?
We're proceeding on count 2, waiving counts 1 and 3.
This is the first major shift in the case. Originally, the indictment included 3 counts, but the prosecution decides to drop counts 1 and 3 and proceed only on count 2. That's significant. Reducing charges often signals a negotiated plea deal, where both sides avoid the risk of a full trial. But here's the key detail. The language of the charge is also being amended in court, removing the words "and violence." Legally, that adjustment can influence how the offense is interpreted and sentenced. So, here's the question. If you were the judge, would you view this as accountability or a major break for the defendant?
And there's some language at the end of count 2 that says end violence, and we've agreed to waive that portion of the indictment. We would make the oral amendment to strike through that language, and it's actually, I believe, in the stipulations marked through.
All right, so in count 2, you all are, well, first, defense, do you have any objections to the waiver of count 1 and count 3?
No, Your Honor.
All right, and then with regards to count 2, the language that is being removed are the words "and violence." Is that correct?
Yes, Your Honor, at the very end.
All right, any objections?
No, Your Honor.
All right, Mr. Deleriva, do you understand that to be a substantive change to the indictment?
Yes.
I'm sorry?
Yes.
All right, do you have any objection to proceeding with that substantive change? I'm sorry?
No.
All right, and defense, are you waiving your 10 days?
Yes, Your Honor.
All right, Mr. Deleriva, I'm going to show you what's entitled Court Admonishments, the Defendant's Waivers, and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate
Yes.
places? Did you understand you're charged with sexual assault? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargaining agreement with the state, the court, excuse me, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, right, for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand by entering this plea bargaining agreement you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Deleriva, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
All right, off the record for a moment. Excuse me. I think the cause number 2022 CR 0065. That's Balboa.
Okay.
All right, we're back on the record. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is proceeding on count 2. There's a $1,000 fine. State recommends deferred adjudication, Chapter 62 compliance, MRT, UAs, and no contact with the complainant. Did you understand that to be the plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes.
And did you sign it in both places?
Yes.
Did you understand by signing that you were waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you what's outside the agreement. The state is recommending that your deferred adjudication be for a term of 7 years. There'll be a TAP evaluation, 80 hours of community service restitution. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes.
Then to count 2, as amended, how do you plead? Guilty, not guilty, or no
No
contest?
contest.
State any evidence.
State offer State's Exhibit 1 is attached into the evidence.
Any objections?
No objections.
Mr. Deleriva, I'm showing you what's entitled Waiver and Consent for Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you apply for deferred adjudication. Now proceeding with sentencing.
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Mr. Deleriva currently is employed. He has no substance abuse problems. He does take all this very seriously. During his brief time in custody, he got to experience how serious the justice system is, and I think he will be performing very well in deferred adjudication. He has no other criminal history whatsoever, and he does take all the charges against him seriously in this situation.
All right. If you're drug tested today, what are the results going to be?
I'll pass it.
All right. Have you ever used any controlled substances?
Yes.
What?
Some marijuana.
When's the last time you used marijuana?
Like 2016.
All right. What do you do for a living?
I worked for DoorDash, but I recently got let off for DoorDash.
I'm sorry?
I work for DoorDash. I used to work for DoorDash, but they let me off of DoorDash because of what was going on.
All right. So again, what do you do for a living? Because you're
Right
not.
now, I'm going to work with my uncle. He works for like cuts grass and stuff like that. Self-employment, basically.
Okay. All right. They want you to do the MRT course. Is this?
Now we reach the moment where the judge shifts from formal procedure to something more direct. Instead of legal language, the judge begins addressing the real issue behind the charge, consent. And the tone becomes noticeably sharper. Because in cases like this, the court isn't just deciding punishment. It's sending a message about boundaries, accountability, and behavior. Watch how the judge explains the concept of consent in the most blunt terms possible.
To tell people don't sexually abuse people? Do we need
Yes.
to be told that?
Yes, Your Honor, it's the moral recognition therapy course.
Somebody don't want to have sex with you and they tell you no, you don't have sex with them. Because then guess what? It's not consensual, it's rape. But here we call it sexual assault. Do you understand that?
Yes.
Are you still meeting people on gaming?
No, I don't have a system anymore.
All right, then you know you can't have a system anymore. You understand that?
Yes.
And here's a hint for everybody. Don't go across country to meet somebody because you met them while playing PlayStation or whatever gaming system is out there, because you really don't know that person. You only know their avatar and not who they are. Right?
Yes.
Do you have any children?
No.
All right, court will sentence you to 7 years deferred adjudication. There's $1,000 fine, probated. Chapter 62 compliance. He used to be on the sex offender caseload. No contact with the complainant. And probation, that's listed in the indictment. There's 80 hours of community service restitution. Probation, I understand that there's no place for registered sex offenders to do community service hours. So the court will waive the 80 hours of community service restitution. If you provide proof of the COVID vaccination, the court is not requiring you to get it, but if you do, then those hours will be waived. I'm going to want a TAP evaluation plus follow recommendations. There's going to be regular reporting by Zoom, well, not by Zoom, in person. Field visits 2 times per month, random. And I'm sure the sex offender caseload probably does it periodically. Proof of employment. There's to be no employment as a home health care provider, no employment as with minors, and there's to be no employment where he is going inside people's homes. So yard work, that's fine, but you cannot do any employment going into people's homes unless you provide proof that that person has been informed or your company has been informed, and you provide that proof to probation. You understand?
Yes.
Is there anything else that he needs probation?
Your Honor, you said proof of employment within how many days?
Within 30 days.
And your analysis?
Yes, we'll do random UAs. All right, is there anything else he needs?
No, Your Honor.
All right, Mr. Deleriva, is there? Yes.
He does currently reside in Houston, Texas, so he will be getting transferred to Houston, Texas.
Okay. Transfer, what county is that?
Harris.
Okay, we'll do a transfer to Harris County. However, you're not transferred to Harris County until probation in their county lets you know your probation has been transferred. Do you understand?
Okay.
All right. Mr. Deleriva, is there anything else you need from the court in order to be successful?
No.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes.
I'm sorry?
Yes.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, good luck to you. We're off the record. So what is up with this lipstick tattoo on your neck?
Huh? Oh, it was when I was like 16. I got it.
All right, is that anyone's lips in particular?
It's just something
Just
I
general?
wanted to get.
Okay.
Yeah.
All right, good luck to you.
So here's the final outcome of this case. Instead of immediate prison time, the judge places the defendant on 7 years of deferred adjudication. That means the court is delaying a formal conviction, but only if he follows every condition of probation. Those conditions include sex offender registration requirements, strict employment restrictions, no contact with the victim, regular reporting and monitoring. If he violates those conditions at any time, the court can still impose up to 20 years in prison. In other words, the case may be over in court today, but the consequences are far from over. And now I want to hear your opinion. Was this sentence fair? Or should this case have gone to a full jury trial? If this courtroom moment shocked you, hit like, share your thoughts in the comments, and subscribe for more real courtroom breakdowns.